Hello, and welcome to the latest in the series of seminars provided by Deans Court Chambers. Today I'm going to look at aspects of costs and offers in applications for financial remedy. The slides will signpost you towards more detailed information which you can explore at your leisure, as I don't propose to delve into the minutiae of the rules in this talk. My suspicion is that one of the reasons why those of us who practice in this field don't always have the strongest grasp of the issue of costs is because costs orders are, as we know to our bitter experience, relatively rarely made. However, I hope after this you may feel emboldened to try. The rule changes last year requiring us to make open offers after an FDR, which I'll come to in more detail later, together with a good strategic approach, can pay dividends. So starting with the basics, there are three cost regimes which may be encountered within the family court and the family division of the High Court. They are costs follow the event, which is the CPR regime in the High Court only, the clean sheet, which is the general FPR regime, and no order, which is what applies to the financial remedy regime. However, that no order rule can be disapplied where conduct issues arise. Since this talk is entitled Costs and Offers in Proceedings for Financial Remedy, it might be prudent to consider what is meant by proceedings for financial remedy. It's important to note that proceedings for a financial remedy is not the same as financial remedy proceedings. Financial remedy itself is defined in FPR Rule 2.3. and it's not the same thing as financial remedy proceedings as defined in FPR 28.3 for the purpose of costs, not particularly helpful. However, the long and the short of it is that in terms of everyday use of the term financial remedy proceedings in relation to costs, where there is a starting point of no order, that applies to the substantive final hearing of an application for an order in financial remedy proceedings. It does include variation orders, but it excludes all interim orders except interim variation orders. It seems anomalous, but appeals in financial remedy proceedings are dealt with in the same way as costs in family proceedings generally. In other words, with a clean sheet, not a no order starting point. It follows from that a Calderbank offer can be deployed. The definition in Rule 28.3 doesn't apply to any other sort of order in financial remedy proceedings, such as interim orders, interim hearings, or final orders arising from, for example, a set-aside application, or determining a beneficial share in property, or disposing of the application in some other way than by making a final financial order. That makes sense when you think about it. In any financial remedy case, even where there's no application for an interim order, there will still be interim hearings. At an FDA or an FDR, no final orders are made except by consent. Therefore, logically, there can be no rationale for applying the no order rule at interim hearings. Rather the opposite. Costs are routinely made at interim hearings to penalise non-compliance, which has caused a hearing, for example, to be adjourned, or to penalise lack of disclosure. And it's worth remembering that many of the rules dealing with financial remedy proceedings are mandatory provisions, so it's worth going on the offensive and trying to get orders where there's been non-compliance. With respect to family proceedings generally, the FPR costs rules open with the provision that the court may at any time make such orders as to costs as it thinks just. That's FPR Rule 28.1. The discretion is obviously at all times subject to the relevant rules, and perhaps not all of us are aware that the court under Section 51, subsection 3 of the Senior Courts Act 81 has full power to determine by whom and to what extent the costs are to be paid, which means that it is possible to order someone who is not a party to pay costs, or that costs can be paid to a non-party. One of the particular features of family proceedings is that the overriding objective, as stated in the FPR, requires the court to have regard to any welfare issues involved, unlike the CPR. Proportionality takes second place to welfare under the FPR. So what are the factors that the court will take into account when deciding whether to make a costs order when the starting point is that there will be no order as to costs? Basically, it comes down to conduct and the conduct within the litigation. The criteria are set out at Rule 28.3, subsection 7, and I'd like to turn now to consider the question of open offers. Since the new Rule 9.27a came into force on the 6th of July last year, not only is the court's increased focus on costs reflected in the additional detail that has to be provided to the court at each hearing, but the real improvement, in my view, is that after an unsuccessful FDR, each party must file with the court and serve on the other party an open proposal for settlement. I have to say I'm pleased with the introduction of this rule, as I disagreed profoundly with Mr. Justice Mostyn that the abolition of Calderbank offers was a good thing. We seemed before to be left with no leverage after an FDR to prevent an unreasonable position being maintained right through to final hearing, or very nearly. We all know that from the point of FDR to the final hearing, costs escalate dramatically, and as the pot gets eroded, it can become more and more difficult to cut a deal. Therefore, the new rule, which requires parties to nail their colours to the mast promptly after the FDR, is, in my view, a very welcome development. Obviously, you can't reference the without prejudice offers made at the FDR in that open offer, not directly, though you can repeat it. One of the objections to the use of Calderbank offers was that a costs order could derail a carefully constructed financial settlement. However, this change in the rules addresses that because the judge is not being ambushed at the end of the hearing with the revelation of a Calderbank offer. Rather, he or she has the information about the parties' respective open positions there in front of him or her. The rules allow any date to be fixed for this to be done, or if no date is fixed, within 21 days of the FDR. I would argue that in the majority of cases, a prompt exchange of offers, ideally before the 21 days expires, would be the most productive. We all know there is momentum at an FDR, and it's good to try and capitalise on it. Also, the offers should be exchanged before costs start to escalate again, for example, in the drafting of Section 25 statements. So at the end of an FDR, give consideration to the date and don't just let it go by default. And if the parties are thinking of having a private FDR, you might want to build the date in to exchange of open offers at the FDA hearing. When making your open offer, bear in mind the escalation of costs and make it clear that your offer is based on the asset base as it currently stands. The offer could be phrased in such a way that any lump sum is to be automatically reduced by the extent that the offeror's costs increase from that point onwards. Alternatively, you could leave the offer open for, say, 28 days. It does have to be for a reasonable space of time, and then say that it's automatically withdrawn if not accepted. Be alive to any substantial imbalance in the cost burden of the parties. Otherwise, simply taking assets at the date of the hearing or the date the offer is made can result in a costs order effectively through the back door. And be careful not to leave offers lying on the table, as it were, as the rejection of an open offer, unlike a without prejudice offer, does not automatically extinguish it. It's good practice, therefore, to withdraw an offer, not leave it lying for someone to purport to accept further down the line. That way could lie further litigation. It's to be hoped that if parties have to nail their colours to the mast at this stage, they will think twice about maintaining an unreasonable position. This, of course, beefs up the provisions of Practice Direction 28A, which specifically says that the court will take a broad view of conduct and will generally conclude that to refuse openly to negotiate reasonably and responsibly will amount to conduct in respect of which the court will consider making an order for costs. This includes in a needs case where the applicant litigates unreasonably. The same provision ensures that the penalty is still felt at the conclusion of the proceedings, as any interim costs order is not to be taken into account as a debt in the computation of assets. A case which preceded the change in the rules is MB and EB. In that case, the husband was penalised for failing to even respond to an offer. That's a very useful case to quote if you can't get any movement from the other side. In the more recent case of OG and AG, Mr. Justice Mostyn explicitly referenced the practice direction, saying, "It's important that I enunciate this principle loud and clear. If, once the financial landscape is clear, you do not openly negotiate reasonably, then you will be likely to suffer a penalty in costs. This applies whether the case is big or small, or whether it's being decided by reference to needs or sharing." Leaving aside that judge's previous objections to derailing carefully crafted orders, let's focus instead on the phrase, "the financial landscape being clear." I take this to mean you don't have to chase down every last piece of information to be able to cut a deal. In many cases, fairly minimal disclosure will be sufficient. It's very disappointing to see relatively small asset bases depleted by unnecessary questionnaires when it's clear that the asset base is exactly what you would expect it to be, and neither party thinks the other has got money hidden. Proportionality really needs to be borne in mind, and we must be prepared to go on the offensive at an FDA to ensure that there is a laser-like focus on what the case is actually about. In the same case, the judge referred to it being a paradigm case for the equal sharing principle to apply to. And practitioners should be prepared to say to their clients, it's going to be 50-50 and not pretend that it's going to be anything different. That also means that if as a practitioner you're on the receiving end of hostile and unnecessary attacks and an unreasonable stance, you should resist the temptation, or your client should resist the temptation to retaliate, because to do so means that any possibility of getting a punitive costs order will be lost if the judge is able to say the blame is on both sides, i.e. neither of you has negotiated reasonably. I guess if you were to ask any layman about costs, they'd probably tell you that the winner gets their costs paid by the loser. Perhaps that's the nub of the problem in financial remedy proceedings. It is sometimes difficult to know who is the winner and who is the loser. But winning in the cost context doesn't necessarily mean a consideration simply of the overall financial outcome. There's also the question of winning or losing with respect to issues that might be placed before the court for adjudication, and that may provide some redress. At the end of the case, the court may need to consider costs in relation to interim applications. One party may argue that an issue has been unreasonably pursued, and the court is able, under CPR 44.2 subsections 6 and 7, to make orders that one party pays a proportion of another party's costs or a stated amount of costs from a certain date only. So where, for example, there's been a set-aside application, that can be dealt with separately on the clean sheet basis, independently of the overall outcome of the proceedings. Where the argument is less clear, for example, not a freestanding interim application, but an argument about whether a case has been unreasonably advanced, causing an escalation in the overall costs, there is authority for the making of an issue-based costs order, and for that I refer you to Mrs. Justice Eleanor King and her judgments in the two cases on the screen. Another case which is worth looking at is the Crowther case. Details are on the screen, and particularly in relation to the hearing of the preliminary issue. In that case, the wife alleged fraud and then withdrew the allegation, and she was ordered to pay costs on an indemnity basis, as would have happened if it were not a family case. The same case also reminds us that the court has the power to order an immediate payment on account of costs, unless there is good reason not to do so. In conclusion, I would say that we should, as practitioners, perhaps think more often about costs. They can be a massive burden to our clients, and if there is an opportunity to obtain at least some redress, we should endeavour to do so. We also serve our clients well by making early, sensible offers. The two issues go hand in glove. Thank you.